Hey everyone, and welcome back. Today's deep dive takes us down a rabbit hole I bet you didn't even know existed.
Okay.
The world of adverse possession in California. You see a for sale sign and you just assume, someone's buying. But what if I told you there's a way to legally acquire property without ever, going through a realtor?
It's true, and it's more common than people realize.
Really?
Yeah, it's not about just like showing up and claiming an abandoned mansion, though.
Right.
There are very specific rules that make adverse possession, well, surprisingly complex.
Right. Our listener sent in a whole stack of articles on this, and I have to admit, the idea that someone could, say, accidentally end up owning part of their neighbor's land just by mowing it for years, well, it feels like we're about to step into a legal thriller.
Mm-hmm.
Where do we even begin?
Well, let's start with the heart of it.
Okay.
Adverse possession happens when someone who isn't the legal owner uses a property in a way that demonstrates ownership for a long enough period.
Okay.
In California, that magic number is 5 years.
5 years. That's it. It feels short when you put it like that, but I'm guessing it takes more than just hanging out on a property to, stake your claim, right?
You bet. California courts look at 5 specific elements, and all of them have to be proven for an adverse possession claim to succeed. Think of it like a checklist with some seriously high standards.
Okay, so let's break this checklist down step by step.
Yeah.
What's the first hurdle someone has to clear?
Number 1 is that the possession has to be hostile. Now, before you imagine a duel at dawn with lawnmowers, hostile in this context simply means the person using the property is doing so without the owner's permission.
So going back to that neighborly mowing example, if I'm trimming my side of the lawn, drift a bit onto my neighbor's side for convenience, and they never say anything, after 5 years of that, could I claim that sliver of their land?
It's not quite that simple. It's not just about the act itself, but the intent and how it's perceived by both parties. If your neighbor was aware you were mowing and didn't object, that could actually work against you because it suggests permission.
Interesting.
To be considered hostile, the use has to be something the owner wouldn't reasonably expect or approve of.
Okay, so if I started building a gazebo on that disputed patch of grass, that would be a much stronger case for hostile possession because my neighbor couldn't claim they were okay with it.
Exactly. It has to be something that sends a clear signal, like, I'm acting like the owner here.
Wow, there's already so much nuance to just this first element. What's next on the list?
So we've got hostile checked off, but now we need actual possession. This one's a bit more straightforward. You have to be physically present and treating the property as your own.
Okay.
Imagine someone setting up a fence, planting a garden, or even building a shed, actions that scream owner, not casual visitor.
So it's not enough to just pop by every weekend and have a picnic on the disputed land?
Picnics don't exactly scream, this is mine now, do they? It has to be consistent and obvious use, something anyone passing by would notice. Which brings us to the third element, open and notorious possession. Think of it like this. If the true owner is paying even a little attention, they should be able to tell someone's encroaching on their rights.
So we're talking about actions, not just intentions. No burying a treasure chest in the dead of night and calling it a land grab, right?
Not quite. Hiding your actions would actually work against you. The whole point of open and notorious is to prevent those kinds of secret takeovers. It ensures that the true owner has a fair chance to notice and object before things go too far.
That makes sense. It's like the legal system saying, look, we get that property lines can be fuzzy sometimes, but let's at least be upfront about who's using what. Okay, so we've got hostile, actual, open, and notorious. What's the fourth piece of this puzzle?
Element number 4 is exclusive possession, meaning the claimant is acting like they have the sole right to decide how the property is used. They're in control, just like an owner would be.
So does that mean they can't let anyone else on the property? What if they have guests over or hire a contractor for repairs?
It's not about being the only person ever on the property.
Okay.
It's about who has the authority to say yes or no to its use.
Got it.
If the claimant is making those decisions, acting like the ultimate decision maker, that points towards exclusive possession.
Okay, so it's about control, not necessarily a strict no trespassing policy. That makes sense. So we've covered hostile, actual, open, notorious, and exclusive. What's the final hurdle in this 5-part legal obstacle course?
The fifth, and this is a big one, is continuous possession for that entire 5-year period. It can't be sporadic or interrupted. Think of it like a game of tag. If you break the chain even for a little bit, you have to start all over again.
So no disappearing for a year to travel the world, then coming back like, all right, 4 more years to go.
Right.
Consistency is key.
Absolutely. And here's where California throws in an extra layer of complexity, an unofficial 6th requirement that often carries a lot of weight in court.
Oh, I knew there had to be a twist. What's this California-specific curveball?
In the Golden State, paying property taxes on the land in question is often seen as a major demonstration of ownership. It's not technically a legal requirement, but courts here have repeatedly upheld its importance in adverse possession cases.
Wow, so not only do you have to act like the owner for 5 years straight, jumping through all these legal hoops, but you might have to foot the tax bill too. That's intense.
It definitely adds a layer of complexity. It shows that the claimant isn't just using the land casually, they're taking on the financial responsibilities that come with ownership.
Okay, so we've covered how someone might try to claim property through adverse possession, but what about the flip side? What can our listener do to protect themselves from these kinds of claims?
That's such an important question, and thankfully there are some proactive steps property owners can take.
Okay.
Knowledge is power, and in this case, it can save you a whole lot of legal headaches down the line.
So what's the number one piece of advice you'd give to someone who wants to make sure their property stays their property?
Regular inspections are key, especially for land that's vacant or not used very often.
Okay.
You're looking for any signs of someone else using your property without your permission. Maybe a new fence encroaching on your side of the property line, or signs of someone clearing land they don't own.
Because like we said earlier, if it's open and notorious, you should be able to spot it.
Right. Exactly. And the sooner you address any issues, the better. A simple conversation can often prevent a legal battle down the road. And here's a pro tip. Document everything.
Oh, okay.
Take pictures, jot down dates and times, and if you have any agreements with neighbors about property, use even casual ones, get them in writing.
Formalize it, even if it seems like a small thing. Got it. Clear boundaries seem like another big one.
Absolutely. If you're unsure about your property lines, getting a surveyor involved can be invaluable, especially for larger properties or those in rural areas. It's about removing that element of doubt.
Okay, so regular inspections, clear boundaries, documented agreements, those are all great preventative measures. But our listener sent in some articles about a particularly tricky situation. Abandoned properties. When a house has been seemingly deserted for years, it's not always clear who the owner even is. Can someone just step in and claim it through adverse possession?
It's tempting to think so, isn't it? But here's the thing. Just because a property looks abandoned doesn't mean it actually is. There might be an owner who's dealing with a difficult situation or heirs who don't even know they've inherited the property.
So before you start measuring for curtains in that seemingly empty mansion, there are some important things to consider.
Absolutely. And even if a property is truly abandoned, claiming it through adverse possession is still a complex process. It's not just a matter of moving in and changing the locks.
Right, because we've already covered those 5 essential elements, and they're not easy to meet. What are some of the specific challenges someone might face when trying to claim an abandoned property?
Well, for starters, you need to be absolutely sure the property is actually abandoned. That means digging into public records, trying to track down the owner, and making sure there aren't any outstanding liens or claims on the property.
Yeah, it can feel like detective work. So it's not just about slapping on a fresh coat of paint and calling it yours. You're really going the extra mile to prove the property is truly unclaimed. What happens next?
Once you've done your due diligence, you then need to occupy the property openly and notoriously, just like we talked about earlier. But with an abandoned property, there's an even greater emphasis on making your presence known.
Okay.
You really want to set a clear message to anyone who might still have a claim that you're the one acting as the owner.
So maybe putting up a beware of dog sign isn't enough in this case.
Maybe not. Think about things like having the utilities turned on in your name, registering the address with postal services, maybe even putting up a fence if appropriate.
Right.
It's about establishing a visible, documented presence.
It sounds like there's a lot more scrutiny on those early stages when dealing with a property that's potentially abandoned. What about those other requirements, like paying property taxes?
That's still crucial, especially in California. In fact, with abandoned properties, paying those taxes becomes even more significant.
Okay.
It demonstrates a willingness to take on, the financial responsibilities of ownership, which can really strengthen your claim.
It's like saying, I'm not just squatting here, I'm investing in this property.
Exactly.
Right.
And finally, You know, if you've met all those requirements, maintained your claim for the full 5 years, you could potentially file a legal action called a quiet title to try to officially claim ownership.
So it's a long and winding road, even in the best-case scenario. This definitely isn't a DIY project for someone who watched a 5-minute YouTube video about adverse possession.
Absolutely not. If anyone listening thinks they might have a valid adverse possession claim, maybe because they've been using a piece of land for years and just recently discovered it wasn't technically theirs, talking to a real estate attorney is absolutely essential.
Right, because as we've learned today, there are a lot of nuances to navigate, and what might seem like a simple land dispute can quickly turn into a legal labyrinth.
Very true. But, all this talk about abandoned properties reminds me of another question our listener asked. What about renters? If you've been living in the same place for years, does that give you any claim to ownership through adverse possession?
That's a great question. I imagine a lot of renters are wondering the same thing. After all, they're paying for a place to live, often for years on end, so. Does that count towards any kind of ownership claim?
Unfortunately, in most cases, the answer is no. Remember that hostile element we talked about? It means using the property without the owner's permission. And when you're renting, you have a lease agreement, a very clear form of permission from the owner. You're acknowledging their ownership by paying rent each month.
So even if you've been a model tenant for decades, always paying on time, taking care of the place, that doesn't give you any grounds for an adverse possession claim.
Right. Now, there might be extremely rare exceptions. Like if a landlord completely vanished, a lease expired decades ago, and a tenant continued occupying the property, treating it as their own, paying taxes, and even handling all the maintenance and repairs independently.
Wow, so we're talking vanishing landlord, lost lease agreement, a tenant essentially acting as the de facto owner for years and years. Even then, it sounds like a long shot.
It would be a very complex legal battle for sure. The key takeaway here is that for the vast majority of renters, paying rent doesn't equate to a path towards ownership through adverse possession.
So if you're dreaming of owning your rental, better to start saving for a down payment than brushing up on obscure property laws.
Exactly. Though I have to say, it's never a bad idea to understand your rights, whether you're a homeowner, a tenant, or just someone fascinated by, the quirks of the legal system.
I totally agree. Knowledge is power, as they say. Speaking of which, we've covered a lot of ground today. We explored the ins and outs of adverse possession in California, those 5 crucial elements, and even tackled those tricky situations with abandoned properties and renter rights.
It's been a fascinating deep dive, and hopefully our listener feels much more informed about this often misunderstood area of law.
Absolutely. And for anyone listening who suddenly feels the urge to double-check their property lines, well, we've definitely done our job today.
A little healthy vigilance never hurts.
Couldn't agree more. Until next time, keep those minds curious, and we'll see you on the next deep dive.
Call now 714-442-9741. Thank you.